there is a opportunity here to explore the nominee's thinking to the extent she can share her thoughts without deciding a particular case that comes before her. Senator Harris, who I respect, suggested you were not candid.
Judge Barrett, several times today you have quoted Justice Ginsburg's testimony about not making predictions in future cases. However, she was far more forthcoming at her confirmation hearing about the essential rights of women.
Judge Barrett, I couldn't disagree more. I think I've been here for a few of these. I've voted for every nominee that has come before the committee. I think you have one thing in common, all of you. You're highly qualified, capable people. I saw that in Justice Sotomayor and Justice Kagan, submitted by President Obama. I definitely did not share their legal philosophy. I expected them to be fairly solid votes for the liberal side of the court, and generally speaking, they have been, but they've done so honorably. I think they have kept their commitment to be fair and impartial, but we do understand judicial philosophy matters. There's differences. I think everybody in America can get 3 hours of credit for originalism. It's the most detailed explanation of legal philosophy I think any nominee has provided to the Senate, and I appreciate that. Senator Harris mentioned about how much more candid Justice Ginsburg was. And with all due respect to Senator Harris, I don't agree with that. I think Justice Ginsburg established the Ginsburg rule for a reason. But what she cited in terms of evidence of candor was a very articulate statement by Justice Ginsburg as to why she embraced the pro-choice point of view. That's not being candid about the law. That's being candid about who you are. I think it's pretty clear to everybody who's been watching these hearings that you and your family are pro-life, that you are a practicing Catholic, and you adhere to the tenets of your faith. But I hope people also understand that you have made a pledge to the committee and to the country at large that you will set aside whatever religious views you have when it comes time to decide the law. There's already been an example in the Seventh Circuit where you upheld a legislative provision that restricted access to abortion clinics in terms of protesting. I think it's the Bubble case. So I'm highly confident that you will judge every American based on their case, not the law of Amy. And here's what is important to me. Senator Blackburn and Ernst are two conservative women on this committee. It is a very give-and-take society called America, but there's one group in America I think has had a hard time of it, and that's conservatives of color and women conservatives. There's an effort by some in the liberal world to marginalize the contribution because you come out on a different side of an issue, particularly abortion. So this hearing to me is an opportunity to not punch through a glass ceiling, but a reinforced concrete barrier around conservative women. You're going to shatter that barrier. I have never been more proud of a nominee than I am of you. You've been candid to this body about who you are, what you believe. You've been reassuring in your disposition. And this is history being made, folks. This is the first time in American history that we've nominated a woman who's unashamedly pro-life and embraces her faith without apology, and she's going to the court. Seat at the table is waiting on you, and it will be a great signal to all young women who share your view of the world that there's a seat at the table for them. This won't be celebrated in most places. It'd be hard to find much commentary about this moment in American history, but in many of our worlds, this will be celebrated. This has been a long time coming, and we have arrived. So I want to thank President Trump for giving you the opportunity to showcase your talents. I believe that Justice Sotomayor and Kagan were incredibly qualified women of great character, disposition, and integrity, and I believe the same about you. So let's talk a little bit about yesterday, Obamacare. This hearing has been more about Obamacare than it has you. Obamacare is on the ballot. If you want socialized single-payer health care, that's on the ballot. Why do many of us object to Obamacare? It was written and passed on a partisan line, I think on Christmas Eve. Most big changes in society have more buy-in than that. You're talking about 1/5 of the American economy. And as I said yesterday, from a South Carolina point of view, this has not worked out well. We started with 5 exchanges. We're down to 1. You have one choice. 4 rural hospitals have closed. Premiums have gone up, not down, by an average of 30%. And when you look at the formula used by Obamacare, I can understand why Senator Harris likes it the way it is. I can understand why Chuck Schumer likes it the way it is. 3 states get 35% of all of Obamacare dollars. New York, California, Massachusetts, they're 22% of the population. In South Carolina, if you had a per patient formula, no matter where you lived, you got the same contribution from the federal government, South Carolina would receive almost an additional $1 billion. I don't blame California, New York, and Massachusetts for wanting more. People in South Carolina should blame me and Senator Scott for accepting that construct. So when it comes to health care, we all have our different positions, but today is about you. And today is about whether or not you're qualified to serve on the highest court in the land. Severability. Can you tell me again, I know you've been asked 100 times, the doctrine of severability, what does it mean? Push the red button. Yeah.
Okay.
Think so. No, I can't hear you now.
It's not.
There we go. There we go.
Okay.
There we go.
So the doctrine of severability is a doctrine essentially of statutory interpretation. And what it means is if you have a statute, and the Affordable Care Act is obviously a very long statute, if there's one provision within the statute that's unconstitutional, the question is whether that one section can simply be rendered null and excised from the statute, severed, so that the rest of the law stands, or whether that provision is so central to the statute that its unconstitutionality, like once it's pulled out, the whole house of cards collapses. And the presumption is always in favor of severability. It's a question of your intent. The court looks... Oh, sorry, go ahead.
The main thing is the doctrine of severability has a presumption to save the statute if possible. Is that correct?
That is correct.
So I want every conservative in the nation to listen to what she just said. The doctrine of severability presumes, and its goal is to preserve the statute if that is possible. So from a conservative point of view, generally speaking, we want legislative bodies to make laws, not judges. Is that correct?
That is correct.
And would it be further true that if you can preserve a statute, you try to the extent possible?
That is true.
Okay. That's the law, folks. Abortion. You were read some statements by, I think it's what's the name of the pro-life group, county?
The St. Joseph County Right to Life.
Okay. And you were asked by Senator Blumenthal, who I respect, whether or not their policy positions were illegal. Do you remember that?
I remember him asking me whether I accepted other policy positions on in vitro fertilization and whether it was a rejection of Roe.
Yeah. Well, I remember an exchange where they took a statement from that group or some other group arguing for the criminalization. Remember that? The criminalization of IBF, is that right?
Yeah, I think so.
Okay. And here's my problem with that analysis. That was a position taken by a pro-life county organization. It's not your job to pass judgment on the thoughts and beliefs of Americans, is it, as a Supreme Court justice?
No, it is not.
So when they argue that something should be criminal, they have a right to make that argument, right?
They do. It also wasn't in the ad that appeared next to the statement I
The
sent.
main thing is, how does something become criminal in our legal system in America?
When a legislative body passes a statute.
So here's what I want you to know. Statements by political organizations are not law. And what we've tried to do yesterday was turn a pro-life group into a legislative body and tried to get you to rule on their beliefs. I think that is a dangerous thing for Americans to be asking a judge to do, whether you're on the right or the left. Here's a statement from an organization I don't particularly agree with, and I want you to pass judgment as to whether or not that's legal. The question for you would be, if some legislative body tried to criminalize this procedure, then that would be subject to litigation in court. Is that correct?
That is correct.
A case in controversy doesn't arise because you disagree with a statement of a private person or a private group. Is that correct?
That is correct.
A case in controversy arises around criminal law when somebody passes a criminal statute. Is that correct?
That's correct.
Then and only then would you determine the constitutionality of that provision. Is that correct?
Well, actually, not even then. The statute would have to be enforced against somebody, so a prosecutor would have to try to hold someone criminally liable for getting IVF, for example.
So the case in controversy concept would have to mature.
Yes, there would be quite a lot of maturation required.
Yeah, before it got to the Supreme Court, if it ever did. So I just want every American to know it's not the judge of it's not the role of a Supreme Court justice to pass judgment on your opinions. It's the role of a Supreme Court justice in very limited circumstances to pass judgment on laws passed by legislative bodies and in other circumstances, regulation, I would suppose. Now, voting. Is it appropriate for legislative bodies to protect the integrity of the ballot box?
So any specific measures that legislative bodies took to protect the integrity of the ballot box could be subject to litigation, subject to challenge.
And that's right. And as they are developed, the courts will hear cases if cases and controversies arise, right?
Yes.
One of the reasons we don't have an agreement with the House is that in their $2.2 trillion package, they're mandating ballot harvesting as a national policy. I think it's ripe for fraud. We've seen evidence of ballots being placed in people's cars and dropped in ditches. So I think there will be an effort, I hope, to protect the integrity of the ballot and also ensure easy voting. I don't think they're contrary goals for the nation. Now, when it comes to being on the court itself and collaborating with other members of the court, what's your experience been at the Seventh Circuit level? How's that played out?
It is so collegial. We all collaborate. I have the greatest respect and have had wonderful interactions with every single one of my colleagues.
Do you think you have the capability to fit in at the Supreme Court?
I hope so.
Okay. So we talked a lot about laws legalizing same-sex marriage. What's the name of the case?
Obergefell.
Okay. And you would, if anybody tried to change that precedent, one of the things you would look at is a reliance interest that people have formed around that piece of legislation?
Yes.
Same with Casey and Roe?
Yes.
Okay. So reaching a decision that the case was wrongly decided doesn't end the debate in terms of whether or not it should be repealed. Is that correct?
That is correct.
And there is a very rigorous process in place to overturn precedent?
There is many factors, reliance being one.
Okay. Is there any constitutional right to a polygamous relationship?
Let's see, that might be a question that could be litigated at, polygamy, obviously, in many places is illegal now, but that could be an issue somebody might litigate before the court at some point.
You know, somebody might make the argument it's possible for three people to love each other genuinely, and that would work its way to the court if somebody wanted to make that argument. Is that correct?
Somebody could, make that argument.
So you've been asked a lot about Roe v. Wade and Casey, and one of the differences between Brown versus Board of Education and Roe line of cases is there's active litigation regarding Roe. Is that correct?
That is correct.
I think Senator Hirano named 8 or 9 different cases that may come up to the court, cases in controversy. And one of the reasons you can't tell us how you would rule is because there's active litigation coming to the court. Is that correct?
That is correct.
And one of the reasons you can say with confidence that you think Brown versus Board of Education is super precedent is that you're not aware of any effort to go back to the good old days of segregation by a legislative body. Is that correct?
That is correct. And I've also said that in lectures that Brown was correct as an original matter. So that is the kind of thing, since I've said it in writing, I felt like I could express before the committee.
When it comes to Heller, there's legislative bodies all over the country passing laws regarding gun ownership. Are you aware of that?
I am aware of that.
Okay, when it comes to Citizens United, I think there'll be some efforts after this election to maybe revisit that case. So the thing that I'm trying to establish here is that Heller, Citizens United, Roe, Casey are all actively being litigated because legislative bodies are playing in that arena. Is that a fair statement?
That's a fair statement.
So your point to us is when it's likely that case and controversies around the holding of a particular case are going to come to the court, there's only so much you can tell us about what you may or may not do.
Absolutely.
So that Roe v. Wade compared to Brown versus Board of Education is not super precedent.
Not super precedent, as I was using that term in the articles that have been referred to.
And let me tell you from a common sense point of view why it's not super precedent. I have legislation. 14 states have passed a law that I'm trying to get passed up here, that in the 5th month of pregnancy, 20 weeks, an unborn child is capable of feeling pain. I'm making the argument there's a compelling state interest to protect that unborn child from a very painful death called abortion. There's only 7 nations on the entire planet that allow abortion on demand in the 5th month. Now, that's a political exercise we're going through. 14 states have passed a version of what I've just described. That will be coming to the court, I would imagine, in the future. All I ask is that will you listen to both sides of the argument if it gets to you?
I will.
Thank you. Judge, all I can say, I've met a lot of people in this business and very impressive people. One of the highlights of my time on the committee is to get to meet incredibly talented, smart, squared-away people. Justice Roberts sat right before you and didn't have a note. A lot of people on my side are upset with him about this or that. Sometimes I disagree with him, but I do know this, that he's doing what he thinks is best for the court and for the country. Justice Sotomayor and Kagan, delightful people, incredibly wickedly smart. Justice Kagan had a biting sense of humor, and they're on the court because they should be. They're on the court because they live lives worthy of being on the court. They're on the court because they're some of the smartest people in the land about the law. They're on the court because they lived incredibly productive and meaningful lives. Justice Gorsuch and Kavanaugh are both on the court for the same reasons. As to you, you're every bit in their league. In my view, this is exactly where you should be going to the Supreme Court, that the United States of America will benefit from your participation at the Supreme Court. You will offer a point of view that millions of Americans share. You will have life experiences that will round out the court. You will apply the law to the facts, and that you are going to inspire a lot of young women, just like Justice Ginsburg did, just like Justice Sotomayor and Kagan did. And the young women that you're going to inspire don't have a whole lot of role models they can point to in terms of the media world in which we live in, uplifting them. That's about to change. To my Democratic colleagues, I understand where you're coming from. I understand what you want the court to do. You want the court to do things differently than we do. I don't question your motives, and I want to thank you for conducting this hearing in a way that has been respectful, has been challenging, and the process will be moving forward here. And from the committee's point of view, I think we're on track to do it in a way that hopefully people will say, even though you disagree strongly, you're not that disagreeable. I'm going to tell you about where I grew up. I don't know why. It just seems to be a good way to end this thing. It's got nothing to do with anything. But I grew up in a small town called Central, South Carolina. And the first of my family to go to college, my dad owned a bar, a pool room, and a liquor store. And my mom ran the bar, and my dad ran the liquor store. And when I was old enough, I ran the pool room. This is why I think I'm a good senator. It's good training for this job. But I remember, speaking about country music, we had a piccolo. You know what a piccolo is, Judge?
I don't know what a piccolo is.
Well, you're too young. Piccolo is something you put money in to listen to the song. And the one song that I remember to my dying day, talk about country music titles, was "My Wife Ran Off with My Best Friend and I Miss Him." So this is a wonderful country. And I just want to say to my Democratic colleagues, I have lost sleep over this hearing. I did not know how it would go. There's a lot of tension. 2020 is the year that is unbelievable in every fashion. You've asked challenging questions of the nominee. You've asked probing questions of the nominee. And at times, you've done some of the things that Senator Blackburn talked about, in my view. But thank you on behalf of the country for allowing us to get through this hearing in a fashion that I think is befitting of the Senate. To my Republican colleagues, thank you for being patient. But this is not about us, it's about you, Judge. I will end where we began. The hope was not to really change anybody's mind. I don't think that's possible in today's environment, and I say that accepting 2020 for what it is. But I'm hoping that people who did not know you better. I'm hoping that young women who are conservative see hope in you, what Senator Blackburn said. I hope people who've listened find your disposition reassuring. You're one of the most amazing human beings I've ever met in my life. And that's saying a lot because I've got to meet a lot of incredible people as a senator and otherwise, serving in the Air Force. Your knowledge of law is just unbelievable, deep and wide. Your judicial philosophy, I think, is very mainstream. You're exactly who a Republican would be looking at picking, not so much a Democrat. And that's not a slam on you because elections have consequences. And to my good friend, Senator Whitehouse, I want to reform the system. It needs to be reformed. But nobody had to spend 15 cents to tell me that you're qualified. I figured that out on my own. I followed your career from afar. And this is the first time I've really had a chance to interact with you. And all I can say is that I've seen a lot of people come and go. We've had some of the most talented people in this country sit where you're sitting. And you've acquitted yourself well. You have much to be proud of. Your children have much to be proud of in their mother. Your husband has much to be proud of in his wife. You have much to be proud of in terms of how you served your country thus far. And with Amy Barrett, the best is yet to come. So, in another time, in another place, you would get everybody's vote. It's not about you. It's about us. Somehow we have lost our way. There's no use blaming one side versus the other. It always seems to be that our people get treated pretty harshly. I voted for Sotomayor and Kagan because I saw in them the qualities that a Democratic president would be looking for and the character, the integrity that the public would appreciate and would be fitting of the job. Elections do have consequences. This vacancy came about through a tragic demise of one of the greatest women of any time. She did things that no other woman was able to do, and through her actions paved the way for women to achieve their goals. She has a different philosophy than you do judicially. That is okay. I hope it's okay that you can be pro-life and adhere to your faith and still be considered by your fellow citizens worthy of this job. I think you have met every test that any reasonable person could impose in terms of qualifications. I think you made every test in terms of disposition and character that the public could hope for in terms of having somebody sit at the table at the Supreme Court. You will be confirmed, God willing. You will have my full support. I see in you someone who's not only highly qualified to be in the court in every way possible, but somebody that has broken new ground in a positive way for the country. So what we will be doing now is go in closed session. The FBI evaluation will be presented to the committee. That's standard practice for every nominee. We will meet again here just in, where's the room? Dirksen G50. You will be with us. We do this for every nominee, going back to Chairman Biden. And it is over. The hearing part is over. You can have 2 glasses of wine tonight if you like.
Mr. Chairman,
Yes.
I'll defer to Senator Durbin if he wants to go first.
Yes, I would just like to finish my thought, then we'll defer to Senator Durbin. The hearing part is over. You acquitted yourself well, but the journey you're about to take is going to be challenging, it's going to be rewarding, and may God bless you in this endeavor.